welcome to the EU Transition Impact on the Workforce webinar. This is the second in our series in conjunction with the Hertfordshire Growth Hub. And we've got more coming up, which I'll tell you about at the end. I'm very, very pleased to say that today we're joined by Paul Brett Young, who is an immigration partner with firm VWV, who'll be speaking in a few minutes. My name is John Woodruff, and I'm Business Support Manager at Hertfordshire Chamber of Commerce. And the webinars are being done in conjunction with our good friends and colleagues at the Hertfordshire Growth Hub. And I'll be introducing Lisa in a second, and then Peter, also from the Growth Hub, will be saying a few words also at the end. I'll just say very, we've got an hour, but there's a lot to put in, so I'll be very brief. Can I just say that the session will be being recorded and will be going onto the various websites, which we'll let you know about. And Tom has very kindly agreed that the slides can also be shared, which is great. Questions and answers, if you could, I'm sure you're all familiar with the setup now, if you could put them into the Q&A box at the bottom, please, and there will be a chance after Tom's finished speaking for me to read out the questions. I might pick on one or two of you as well. We'll unmute you if they're quite long or a bit more complex. You can ask yourselves, but please put them in the Q&A box. And I think that's about it really for me. So if I now introduce you to Lisa Armstrong, who is the Business and Strategic Development Manager with Hertfordshire Growth Hub. Lisa, over to you.
Thank you very much, John. Good morning, everyone. Let me just share my screen for you. Hopefully you can all see this. So I just wanted to have the opportunity to tell you a little bit about the Hertfordshire Growth Hub. I'm sure that many of you are already familiar with our services, but for those of you who aren't, it's just an opportunity to find out more how we can support businesses. As I say, we're really pleased to be working with the Hertfordshire Chamber of Commerce on these sessions. The Growth Hub is led by and delivered on behalf of Hertfordshire Local Enterprise Partnership. We are delivered by a consortium of partners led by business support specialists Exemplis, with the University of Hertfordshire and Hertfordshire Chamber of Commerce. Our support, importantly, is free to access and is available to all businesses in Hertfordshire, including the third sector. We are the central point of access for business support in the county, and we work really closely with both publicly and privately funded partners to be able to bring you a range of services in support of our advice. This could include help to access fully funded staff training, for example, through the Serco Skills Support Programme. And we also are able to provide advice on funding and finance options and much more. One of our core programmes is our Get Growing Too programme. The eagle-eyed among you will spot that European Union logo on the bottom of this slide. This is a funded programme of support which really aims to help businesses in the county that are growing or those that would have been growing prior to COVID and need some help now to respond, adapt and strengthen. Through this programme of support, businesses can access in-depth support through our growth account managers who will work with them to understand their key issues and to be able to put together an action plan and support them in implementing that within the business. There is also the opportunity to access a match funded grant through this programme as well. The EU Transition Readiness Support Programme, of which this webinar this morning is the second in a series of 4, is really been brought to light because obviously EU transition, there's been a lot of unknowns for businesses and a lot of businesses have been sidetracked during the period of the COVID pandemic. And it's really around helping businesses to understand what they now need to do to take action with regards to the new rules after transition. We have a team at the Growth Hub of 5 EU transition advisors that can help you understand what actions your business needs to take, and later on this morning you'll hear from Peter Cabon, who's one of our EU transition advisors. Of course, as I've mentioned, businesses are also busy handling the difficulties that have come with COVID-19. Throughout the year, since March last year, we've been really working with businesses to make sure that we provide up-to-date information and guidance through our COVID-19 resource page, and also through a programme of support known as the Volunteer Business Support Scheme. This has been set up with our consortium partners, the University of Hertfordshire, and we have a network of volunteer mentors that have been assisting businesses that have been impacted by COVID-19. And this programme is set to continue throughout the year. So please do, if you are interested, do speak to us and we can give you more details. We also have an on-demand series of videos on our website in the Knowledge Bank. These cover a variety of topics. There are some on EU transition, also on digital and trading during COVID. These videos are very easy to watch in your own time, last between 15 and 35 minutes. The Wellbeing and Resilience programme that we have at the Growth Hub is really as a result of the impact of COVID-19 on businesses. Of course, we know that everyone's been affected differently through the pandemic, but it's really around providing support to business owners and their workforce, helping them to understand the advice and support that's available to them locally. We've worked in partnership with Hertfordshire County Council to bring you this programme, and part of that programme is a manual and toolkit that's been developed by Hertfordshire County Council and UCL, and that is available to download on our website. We also have an events programme and a series of on-demand videos. So do have a look at our website. Registering for all the support that you've heard about just a few moments ago is available on our website. You can sign up within just a couple of minutes, have a look at some of the support programmes that we have, and you can also request a follow-up call. So please do register. And thank you very much. And I will hand you back to John for the rest of this morning's event.
Thank you very much indeed, Lisa. Brilliant. A lot packed in those couple of slides there, but thank you indeed. What we're going to do now, get you to do a little bit of work. First, we just very quickly, before we ask Tom to speak, could we just ask you to answer 3 questions, please, on a little poll that we've got, just to help us build up a bit of knowledge. So, Sarah, I don't know if you're ready to put the slides up, please, for the questions. Lovely, thank you. So the first question, so it's only 3, don't worry. Biggest concern currently, what's your biggest concern relating to the EU transition? So I'll give you a couple of moments to click a multiple choice, that one. Okay, I can't see obviously on the screen, but I'm assuming everyone's done that. So slide 2, please. Okay, oh, we got the results first. Okay, grand. Okay, well, as you can see from that, workforce and people is #1, which is very relevant for today's topic, which I'm glad to say. VAT, surprisingly, I'm getting loads of questions on VAT, only 13%, but the next 2 highest, importing and exporting, fair enough, and regulation compliance. Okay, well, I hope the EU transition webinars we're running will cover most, if not all of these topics. So yes, so #2, please, when you're ready. And how prepared do you feel your current business currently is? If you could just pop up the answer in the box there. And Sarah will pop up the results from that in a second. Need some guidance. Okay, a large percentage, as I suspected, and now very prepared. It's interesting, we did this a few months before the deal, and it was a very, very different setup actually. Not prepared, still only at 8%, unsure, which is still quite high. Okay, thank you very much indeed. And the last question, please, Sarah, you ready? This is HGH Helper, Hertfordshire Growth Hub Help. Would you like further support from the Hertfordshire Growth Hub EU transition team? Okay, so on that one, we won't publish the results, there's no point, but what we'll do is we'll collate those, and anyone who says yes, we'll put it all through to the Herts Growth Hub, and Lisa or our colleagues will be in touch with you very shortly to see how they can assist you going forward. Okay, right, I think that's it. Tom, over to you, please. Tom Brett Young, as I mentioned, immigration partner at VWV, he's a specialist in immigration law, advising on the full range of immigration issues, with a particular focus on advising employers across all sectors. Tom assists clients with sponsor license applications, sponsorship under tiers 2 and 4 of the points-based system, and via and leave to remain applications. applications under all immigration categories. And lastly, he also delivers training on immigration issues, which is useful, such as compliance with sponsorship duties and how to carry out compliant right to work checks, and assists clients with mock sponsor license inspections and audits of their immigration records. So I imagine, Tom, you're quite busy, so thank you very much indeed for spending an hour with us today. And without further ado, over to you, Tom. Thank you.
That's great, John. Thanks very much. I'll share my screen and see if I don't think I am sharing my screen there, am I? Or I am, but I'm showing the wrong bit. Let me try that again. There we go. You have my slides. Perfect. Lucky I didn't show you the absolute car crash that is my inbox at the moment. Well, great. Thanks very much for that introduction, John, and really interesting to see the results of those polls. While it's not good that people are having difficulties and are concerned about people and hiring and workforce issues, that certainly does help make me think that my own existence is justified somewhat at the moment. My overriding existential dread throughout the entire pandemic is that people will realise that they don't need to travel anymore and won't need visas, and there will no longer be any work for immigration lawyers such as myself. But fortunately, so far we've been kept pretty busy, and I have to say that Brexit's certainly one of the issues which is keeping us occupied at the moment, and I suspect will continue to do so over the coming years. So really just a quick summary of what we're going to go through this morning. I'll give you a quick overview and update with regards to what's changing as far as the UK's immigration system is concerned. I'm going to spend a bit of time focusing on the skilled worker category, the new immigration category, which is probably going to do much of the heavy lifting as far as the immigration system is concerned, certainly in the short to medium term. Look at some of the other notable changes as far as work visas or employment immigration is concerned, and then finally we'll finish up just by looking at what's happening, just some tips and hints in relation to employment of EU nationals now that the Brexit transition period has concluded. So what's changing as far as the immigration system is concerned? Well, the government have been very keen to fanfare the introduction of a new points-based immigration system. Those of you who tuned in early will have heard John and I reminiscing ever so slightly about the Labour government's introduction of a points-based immigration system back in 2008. So this rhetoric isn't by any means new, but it does seem to be something which the focus groups that the government listened to seem to like. So here we are again with another points-based system being introduced, and the plans for this were really laid a good year or so ago. And then the actual introduction of the system of the new immigration routes started to take effect from the beginning of October, as you can see. So the student immigration categories were replaced by new immigration categories, although really the effects of those changes were fairly limited. But that took place on the 5th of October. 1st of December, we had an absolutely tremendous earthquake as far as immigration law was concerned, in that the immigration rules were pretty much scrapped and republished with a new 500-page statement of changes. Most of that was really just tinkering around the edges, redrafting, renaming some categories, but the main category change was that of the change from Tier 2 general to skilled worker, which I'll come on to in a bit more detail shortly. 1st of January was where the really big seismic shift occurred, and that's when free movement rules, which EU, EEA and Swiss nationals previously benefited from, are deemed to have stopped applying any longer in the UK. So from 1st of January onwards, we're now in a position where an EU national, an EEA national, or a Swiss national, and just sort of to get that terminology out of the way at this stage, European Union, European Economic Area, Swiss nationals, all treated the same as far as our immigration laws were concerned. They continue to all be treated the same under the new rules, but they're now lumped in with rest of the world as far as requiring immigration permission. We've had a new immigration category introduced on the 31st of January. I'll mention that ever so quickly towards the end. A new immigration category for Hong Kong residents. And then in the summer, there'll be another immigration category introduced, a post-study work category. So international graduates who've graduated from UK universities will be able to apply for extensions of stay that will allow them to continue working. And that's something that I suspect quite a large number of employers will benefit from, and we'll start to see certainly from recruitment activity from September onwards. The skilled worker category, as I say, it replaces the old Tier 2 general category. For those of you not familiar with it, this is an employer-sponsored immigration category. So an employer who wants to employ somebody in the UK can apply for a license which allows them to sponsor the visa application of somebody who's coming to do a skilled job in the UK. That was the same under the old category as it was called, Tier 2 General, and it's still the case under skilled worker, so you still need a license. Interestingly, depending on your perspective, if you had a Tier 2 General license on the 1st of December, that automatically became a skilled worker category. You didn't have to do anything about it, which really is further grist to the mill of those of us who said that really this was just a name change and not much more. But actually there were some fairly significant changes to that category. So the minimum skill level requirements under Tier 2 General was RQF level 6, graduate level jobs. That's now been reduced to RQF level 3. So there's a lot more jobs now which qualify for sponsorship under this category. There was a rather bureaucratic hoop jumping advertising exercise, the resident labour market test, which has been pretty much scrapped now under the skilled worker category. So that makes things much more straightforward if you are looking to sponsor somebody under this category. Under Tier 2 General, there was a cap that's been removed. And where do we get our points element for this new category? Well, it only really kicks in relation to the salary requirement. So the sort of the headline, or the minimum salary required in most circumstances will be 25,600, or the going rate for the particular job which somebody's coming to do. There's a published list of occupations and the rates which each of them need to attract. Whichever is the higher of those two salaries, 25,000 or the 600, or the going rate for that particular occupation code, is the one that you need to pay. But where the points element for this category kicks in is that there are discounts available in certain circumstances. I'll come on to those in a moment. Quite a significant change as far as I'm concerned is the ability to switch from different immigration categories into the skilled worker category. Under the previous rules, there was a sort of quite tightly prescribed list of categories which you could switch from. Now we've got a short list of categories which you can't switch from. So you can't switch from visitor, for example, but it's now much easier to switch from other immigration categories. So if someone's here as on a working holiday visa, or a youth mobility scheme visa, previously they couldn't switch into skilled worker, now they can. So that does make things much more straightforward, and certainly cuts down on air miles and those sorts of things. Finally, just to flag that there is an English language requirement under the skilled worker category. There was previously. That really continues in much the same vein. Certain nationalities are exempt, but otherwise the individual will need to have English at a reasonable standard in order to get the visa. Just as by way of illustration, in terms of the reduction in skill level, just to sort of give you an idea of the additional jobs which are now opened up to sponsorship, under Tier 2 General, we really we're quite restricted in the sorts of jobs that somebody could be sponsored to do, as it says on the slide, typically director, senior managerial, professional type roles. Reducing the skill level to RQF levels 3 and 4 opens that up to far greater number of sort of middle management type roles or technical roles. So as you can see on the slide, office managers, human resources managers, lab technicians, those sorts of jobs are also, can now be sponsored. Important to note that there are still some jobs which are excluded from the system. So we have a list of lower skilled jobs within the immigration rules which wouldn't qualify. So it's really important that you make sure that the job you're sponsoring somebody to do couldn't be better described as one of those lower skilled jobs. That will mean that you'll sort of fall foul of the Home Office and their compliance officers. So do watch out for that. But as I say, generally speaking, we'll find that much wider range of jobs now are opened up for sponsorship. But the quid pro quo of that, of course, is that while far more jobs are open and available to be sponsored, this is going to hit you in the wallet. So we've got some pretty eye-watering fees which will need to be paid either by the individual who's being sponsored or by the business which is sponsoring them in order to get them over here and working for you. So I won't go through them in detail, but we've got a sort of number of different fees, surcharges levied at various points in the application process. And as you can see from the slide, if you're someone, if you're a family of 4 and you're applying for 5-year visas to come to work for somebody under the skilled worker category, between the business and the individual, they'll be looking at government fees of in excess of 21,000. That's not including English language testing, tuberculosis testing, legal fees if you're having legal support. So it's and this is this is quite deliberate. I mean, the government have been ramping up these fees for some time. Their view is that if you benefit from the immigration system, you should pay for it. They want the immigration system to be self-funding. So there's only one way that the immigration fees will go, and it's not down. Just to flag some other relevant changes as far as the immigration system is concerned. So as I mentioned earlier, we've got the graduate route coming in from the summer. So that's a 2 or 3 year extension, which will allow a graduate to work in the UK, find a job, maybe start a business. So that's as I said earlier, that's something which will certainly be relevant to quite a number of employers, I suspect, and will be seen as a good sort of stepping stone between university and maybe finding a skilled worker sponsor. So I suspect that will be pretty popular. Global talent is a category for what they refer to as exceptionally talented or exceptionally promising individuals. You require an endorsement in various fields, so usually the sciences, the arts, digital technology would be the more common ones. And as I've said on the slide, there were some tweaks to that category, mostly around making things easier for senior academics. But again, that's another non-sponsored immigration category that you may come across from time to time. We've got a number of short-term or sort of temporary worker categories, which will continue in pretty much the same vein. So UK ancestry is a category for Commonwealth citizens with a grandparent who was born in the UK. That allows them to come to work in the UK. That remains unchanged. And then these temporary worker categories, youth mobility, charity workers, creative workers, again pretty much unchanged. And then the government have talked about introducing a further new category, an unsponsored category for highly skilled workers. We don't really have any more detail than that which is on the slide, just that it will be capped, unsponsored, and for highly skilled workers. So watch this space for more details on that. I wouldn't expect that to be introduced anytime soon. I mean, sort of towards the end of this year at the very earliest, I would suggest. What about this new category for Hong Kong residents? Well, it's quite interesting. Indulge me as far as the history of this is concerned. So when Britain handed back control of Hong Kong to the Chinese in 1997, they, or in the lead up to that handover, they created this new citizenship status, British national overseas, which would allow residents of Hong Kong to maintain some continuing links to the United Kingdom, albeit holding that citizenship didn't really give them any huge advantages, other than it would allow them to come to the UK as a visitor rather than having to get without getting a visa, rather than the position for Chinese nationals, which is that they would need a visa just to come to the UK on holiday or for a business visit. So there was a sort of minor advantage to holding this citizenship status, but not a huge one. But nevertheless, lots of people did apply for that status, having sort of grown up in a Hong Kong that was governed by the United Kingdom, and then following sort of concerns around sort of changes in the central Chinese government's control over Hong Kong, which really came to a head last year, the government said that, you know, because those changes sort of threaten the security of the of Hong Kong, they were going to create this new immigration category so that anybody who felt unsafe there or no longer wanted to live there could relocate to the United Kingdom. So we have this new Hong Kong British national overseas visa route. And what's interesting about it is that it's a pretty straightforward immigration category. It's open to a wide number of people, not just to British national overseas citizens, who are a sort of closed group of people. The applications for that status closed in 1997. So if you weren't born in 1997, you can't be a British national overseas citizen. But you could have a parent or a grandparent who has that status, and provided there is someone in the family with that status, then potentially the whole family can relocate to the United Kingdom. So while we're stopping free movement for European Union citizens, there's potentially a rather large group of people in Hong Kong for whom it's not quite free movement, in that it does require a visa, but it's not too far off in that the requirements aren't hugely onerous. And unlike the visa application fees that we saw for the skilled worker category, we're only talking about £250 for a 5-year visa, which again, for some people will be a not insignificant amount of money, but when you compare it with some of the other immigration fees, is really very low. So quite an interesting development. I suspect that quite a large number of people will look to relocate on the basis of this visa category. As I say, I think it looks pretty straightforward. I'm not envisaging a huge amount of work for me or my team, because most people will be able to make the application themselves. But as employers, I think it's something that you should probably be aware of if you're talking with somebody in Hong Kong about a job, worth seeing whether they or their family are eligible for this visa. Yeah, it would be a far easier category for them to apply under than pretty much any other if they qualify. Okay, moving on to EEA Nationals before I shut up for a while and respond to some of your questions. So just to sort of summarise what the situation is for EEA Nationals who are already resident in the UK. So Before the transition period ended, the government introduced an immigration category called the EU Settlement Scheme, which looks to grant status to EU nationals who are resident in the UK before the 1st of January 2021, so before the end of the transition period. Applications are free, really straightforward, they're done online. You don't even have to attend an application centre. In most cases, you can do the identity verification steps using an app which you download to a mobile device. Deadline for those applications is the 30th of June 2021. So we've got less than 5 months left now in order to make applications. And as I said earlier, you can apply if you're an EU national who was in the UK before the 1st of January 2021. Because we've got this sort of grace period, or this runoff period following the end of the transition period, the government said that right to work checks will continue along the same basis as they did before, during the transition period before Brexit. So you can still, as an employer, you can still accept EU national passports, identity cards as proof of right to work. You don't have to insist that someone's applied under the settlement scheme, because they've got until the 30th of June to do so. I don't need to tell you, as the third bullet point says, I don't really need to tell you not to discriminate, but that is quite clear in the government's guidance. What they're saying is, you can't say to an EU national who's about to start work, you must. You can't start work until you've demonstrated that you've been granted status under the settlement scheme, and that's because they've still got this runoff period. But you may want to consider how you deal with any job applicant, really, but particularly those from EEA countries, because there may be some people who are applying for jobs who won't be eligible to apply under the settlement scheme, and there will be some who are applying who are eligible but either weren't aware or didn't think they needed to, or thought they had plenty of time. So it is worth thinking about some wording in your adverts or in your recruitment documentation, which just sort of flags up the idea that some people may need to think about whether they are entitled to any other form of immigration permission if they're not going to qualify under the settlement scheme, and you're not going to sponsor them. From the 1st of July onwards, we will have new guidance on right to work checks. I mean, I hope we see it a little bit before that as well, but it will be enforced from the 1st of July onwards, and that will require you to check that EU nationals starting work from that date onwards have something such as the EU settlement scheme or some other form of immigration permission which allows them to work. So just thinking about that sort of through in a practical way. So as I've said already, we can accept EU national passports and identity cards up until the 30th of June. For EU nationals who started work before the 1st of July, if you've done a compliant right to work check on their ID card or their passport, then that will continue to protect you. So you don't have to go back and start asking EU nationals who started work before the 1st of July, can you now demonstrate that you've applied under the settlement scheme? But the checks that you've done on them previously will be effectively grandfathered in. So you'll continue to benefit from the protections that those checks gave you. Unless, as it says on the slide, you have reasonable cause to believe that they've lost the right to work. Best example I can think of here is 1st of July, an EU national wanders into the HR office and says, I forgot to apply under the settlement scheme. At that point, you know or have reasonable cause to believe that they may have lost the right to work. And so we're going to have a tricky situation. So that's the reason why I think really as an employer, you should be sort of thinking about how you communicate to EU nationals that there is this deadline, they need to apply. I don't need to see proof that you've made that application, but just please make sure that you do. Otherwise, we're going to have we could be in a tricky situation in the future. And then, as I've said already, all new employees from the 1st of July onwards will have to show they've got the right to work, and you'll be subjecting EU nationals at that stage to the same level of checks as you would a US citizen or a Nigerian citizen who is applying for a job with you. Worth flagging as well, just that final point in brackets there, EU settlement scheme status and any immigration status granted to EU nationals will in the majority of cases not be on a physical document. It's going to be as a digital immigration status that you access online. So it's a bit of a rigmarole. The individual will give you a share code, and then you use that share code to look up their status online. So that's something we're going to have to get used to doing. It will be a bit different than just simply looking at someone's passport or a residence permit. I just want to say quick few words on visitors from the European Union. I'm not talking about citizens going to the European Union, because each country will have its own rules about work visits, and there's been lots of talk about that. And quite frankly, I have enough trouble keeping on top of UK immigration law. I would struggle if I was going to try and advise on the immigration laws of each of the EU member states as well. If you're part of a corporate group with offices in the European Union, you might have colleagues who've been visiting you from EU offices on a regular basis. And if that started before the 1st of January, they may be eligible for what's called a frontier work permit, which will allow that arrangement to continue. If they don't qualify for a frontier work permit, then you're going to have to start thinking carefully about what visitors to your offices, be it part of your corporate group or be it people trying to sell you things or clients that you're working with, they will have to start thinking carefully about the things that they can do in the UK, in the UK, because they will be subject to the UK's visitor immigration rules, which say things, for example, like you cannot sell directly to members of the public, you cannot provide goods and services. There are certain permitted activities, so you can attend meetings, you can negotiate and sign deals, you can gather information for your overseas employment. So if it was a consultant, for example, coming to work with you, they can fact find while they're here, but the sort of the donkey work, the heavy lifting will need to take place after they've left the UK. And there are some intra-corporate activities, again, if you're part of a corporate group, that are permitted within the visitor rules, but they can't involve client work, and they can't involve providing short-term cover. So if you've got members of staff off sick, you can't, as you would have done last year, say to a colleague in the European Union, oh, if you come over for a couple of months, we'll put you up in a hotel, we'll meet all your expenses, and you can provide cover for the colleagues who are unwell or have unexpectedly left while we look for a permanent replacement. Short-term cover is explicitly prohibited by the visitor rules, so it's something you've got to watch out for, as is this prohibition on what they refer to as frequent and successive visits. So the headline restrictions as far as visitors are concerned are that you cannot stay in the UK for more than 6 months at a time. But if you're visiting the UK frequently, and if the immigration officers who see you think that you are using the visitor category abusively, and really you should get some longer term visa because you're coming to the UK so regularly, then they can refuse entry on that basis. So something else to watch out for people who are regularly visiting the UK, particularly if it's for extended periods of work. So a few sort of quick sort of things to flag, just in terms of planning. As I mentioned earlier, do make sure that all EU employees are aware of the settlement scheme. Think about where future recruitment is coming from, and whether you might need a sponsorship license, or to think about providing immigration support to those individuals. So do you need a sponsor license? If you've got one already, is it compliant? Are you confident that you're doing everything that you should be doing as far as record keeping, reporting changes in employment, those sorts of things? If you are going to be in a position where you are sponsoring more people in the future, or start sponsoring people in the first place, does your HR team need more resource to support that? Do you need to hire additional people to help operate that license? Do you need to get that support in externally? That sort of thing. So if you've not thought about these things already, do start to think them through. All right, that's my waffle over with. I think we have some questions, do we, John?
We do indeed, and Tom, hardly waffle. Thank you so much indeed. All very, very useful and great information for people. So please don't think it's waffle. Oh, I've lost my screen. Sorry, I don't know what's going on there. Right, it's better.
Sorry, I stopped
yes.
sharing.
Yeah, that's right. No, it's not a problem. Thank you for that. Just very interesting, but the note about Hong Kong being an ex-China watcher, still am to some degree. China obviously recently saying they don't recognise the BNO passports anymore from the end of January. So I think that's going to squeeze even more Hong Kongers to come this way. And from what I hear, so it's going to be very interesting to see it, which is against the '97 agreement, of course. Right, I've got a couple of my own questions, but I'm very pleased to say we've got some in the box, as you mentioned. So question number one from Sharon Davis: can I check that care staff are still not included?
Not included in what? I mean, if it's an EU national carer, then and they're travelling in and out of the UK, then no, they're very much subject to the UK's immigration rules. I'm not sure if that was in response to a particular point I was making at some point in the presentation, but or unless it means within the skilled worker category.
It might well do. Sharon, are you with us? Sarah, can you see? Oh yes, Sarah. Sorry, I meant in the exemptions. She's come back and said.
I'm still not quite clear.
Sharon, if you're there, Sarah, could you kindly unmute Sharon, please? She can ask direct, but it's probably easiest. There she is. She's coming.
Yeah, so what I was just trying to get at is we work with care staff in Hertfordshire, and we know that that's they don't meet the criteria for the level 3.
Okay.
So just really wondering whether that has been looked at again, because I know at one time they were saying definitely no, but I was just hoping that maybe it had changed.
Yeah, no, so yeah, thank you. Yeah, so that is in relation to the skilled worker category, and obviously, I say obviously, carers didn't qualify at all under the Tier 2 general category. Senior care workers will qualify under the skilled worker category. So senior care workers are classified at RQF level 3, but that will be team leaders. That won't be. Yeah, the sort of day-to-day care providers. So no, they are still excluded from that category, unfortunately.
Thank you.
Okay, thanks, Sharon. Right, the next one. Are you aware of ways that the immigration system can help businesses to attract skilled staff from French-speaking countries, e.g. Algeria, which have many qualified engineering graduates looking for jobs?
Well, the government's mantra throughout all this is that we don't distinguish or discriminate now between people from different parts of the world. So unless you are a British or an Irish passport holder, or you're from a country like Hong Kong or a Commonwealth country where you might qualify for that UK ancestry category, there aren't really any benefits from being a particular nationality. So I can't think that there's anything that would be of specific interest or relevance to an Algerian national. But if it's a qualified engineering graduate, they would almost certainly qualify under the skilled worker category. The difficulty might be on their English language ability. So if they can't speak English at all, then they're going to have to take some classes in order to qualify under skilled worker. If you're part of a corporate group, then the intra-company transfer category, which allows transfers to the UK of up to 5 years in most cases, doesn't have an English language requirement. So that might be a way of getting individuals like that into the UK quicker. But unless there's an international network or sort of corporate structure, then it would be skilled worker, and would be looking at trying to improve their English language skills before they qualify for the skilled worker visa.
Thank you, Tom. So one of my own questions, we've got 2 more questions, can't we? We've got time to include those. But on the English language side of things, who decides whether your English, not yours, but the applicant's English is good enough to come into the country? Who decides that?
It's quite objective. So there's a list of majority English speaking countries for who are broadly exempt. So Australia, Canada, New Zealand, the United States would all be exempt from the English language requirement. Then if you have a degree which was taught in English, and you can get equivalency certificates from UK NARIC, who will tell you whether the degree was at UK degree level standard, and B, whether it was taught in English or not. So they've got a database of these things. So that would be another way. But if you don't have a degree taught in English, if you're not from a majority English language speaking country, then it's off to a test centre and passing a prescribed test. It's not just any test that Joe Bloggs down the street's running. It's IELTS run by the British Council or equivalent, and I mean, I think the exams take sort of 3 or 4 hours because it looks at listening, speaking, reading, and writing. So, and there's a standard you have to reach in order to qualify for the visa.
Which is fair enough. Okay, Graham, thank you. Next question from Michelle. After the 1st of July, are you entitled to ask a candidate what nationality they are, or is that discrimination?
Well, I think you have to be a little bit careful. I mean, you should already be asking not necessarily about nationality or immigration status, but whether somebody has the right to work in the UK, and you are entitled to ask for them to be able to prove that they've got that right to work in the UK. Now currently that's done, that could include a European national's passport. From 1st of July, it will have to be something else, and so the list of prescribed documents will change. And if somebody on the 1st of July produces a French passport, they will need something else, and that will, in many cases, be proof that they've been granted status under the EU settlement scheme. But if they don't qualify under that, maybe they've married a British citizen and been granted a spouse visa, for example. So it could be a whole number of things. So it's not necessarily about asking for their nationality, but asking for them to prove that they've got the right to work in the UK. And that could be by way of a British passport or an Irish passport, or it could be by demonstrating they've been granted an immigration status that allows them to work.
Okay, thank you. Next one from Tony. Can you tell us where we are with the seasonal agricultural workers scheme? Also, I understand citizens from EAS, Republic of Ireland, are an exception to EEA rules.
Yeah, so on the second point, yeah, Tony's absolutely right. So we still have a free movement zone. It's just that it's restricted to the British Isles. So an Irish national also benefits from no immigration checks, and is free to come to the UK and work without any additional permissions or restrictions. Seasonal agricultural workers is still, I think, officially in pilot mode. So this is a scheme which allows certain recruiters to obtain a license to get gangs of fruit pickers over to the UK in order to ensure that we've not got strawberries rotting in the fields and what have you. So I think I saw the other day that the scheme is being expanded, but it's still officially a pilot, and you have to be an approved sponsor in order to in order to be recruiting people to come to do this work. So it's still pretty limited in its nature, and it is only to use the technical jargon, it's still restricted to the edible horticultural sector. So it doesn't apply to coffee shops or any other sort of seasonal work or tourism or hospitality or anything like that. It's still very much within the sort of fruit picking sector.
Brilliant, thank you. And of course, in Herts, we have quite a few companies in that very sector. Last question we've got on the chat box, and we'll move on to Peter, unless we get any more questions. Rose Davis, quite a long question, that quite involved. If you're still there, Sarah, would you like to let Rose in and ask the question to Tom direct, please?
Hi everyone. So we've been making existing staff from the EEA aware of the settlement scheme. So my understanding, I just want to double check this because you mentioned something in your talk there. I just want to double check that my understanding is that other than making them aware, we don't need to do anything else, including checking that they have applied for the pre-settled and settled status. Because you mentioned earlier that only if you were to become aware by someone coming into the HR department, then you would follow it up. But what happens if, you know, we're not made aware at all, you know, and say we've got someone in 2 years' time that's been, you know, employed with us, and we find out that they haven't applied for the settlement scheme. You're saying that we can go to the original right to work documents, which, you know, at the time was free movement, so we could employ them.
Yeah, no, that's absolutely right, Rose.
So that's fine.
Yeah, no, it is, and it's a somewhat counterintuitive.
Nervous about it.
but that's where we are. Yeah, so the checks that you've done on them already are, as I said earlier, sort of effectively grandfathered in, so that while they continue working for you, then you continue to have that excuse and that protection that the earlier check gave you. So yeah, you're not required to do anything. I mean, certainly some employers have been asking for proof, but you know,
I've heard that we're not allowed to do that.
Well,
we're not allowed to actively ask for proof, or if they give it to us, then that's fine, but we're not to actively do that. So we're not doing that. We're just sort of making them aware.
And I think that's absolutely fine. I mean, you can ask, but it does then run the risk that then somebody is more likely then on the 1st of July to say, "Oh, I forgot," or for if you're not doing it, you know, very rigorously, then your system's not being your records showing that you didn't check up on everybody, and so then there's potentially other issues arising. So some employers are checking, but if you do it, you've got to do it and make sure that everybody applies.
Right. Okay.
Yeah.
Right. Okay. Thank you very much.
Yeah. Thanks for your question.
Thanks, Rose. Great. Lovely. Thank you. Well, there's no more questions in the chat box. Tom, thank you so much. I think you said at the beginning you were very happy if people wanted to come to you direct and ask questions. So if that offer is there, then
absolutely. So I think my details will be circulated and they're on the slides, which will also be circulated. So yeah, right. any questions you'd rather not raise here, just drop me a line. That's fine.
Thank you so much, and thank you for your great your insights. Really grateful for that. Thank you. Peter, over to you. We're waiting very patient there. Peter Cabon is the EU Transition Advisor at the Hertfordshire Growth Hub, and you're going to say a few words, I believe.
Yes, thank you. Lisa mentioned the transition team in Hertfordshire. It was set up in mid-December. So we're quite new. It was set up in response to the Department of Business, Energy and Industrial Strategy asking that growth hubs have a facility that included advisors to proactively contact companies and establish how prepared they felt for Brexit and EU transition, but also to offer assistance where required. So Lisa mentioned 5 advisors within the team. The offer is, or could be, direct one-to-one advice. It might be communicating up-to-date, relevant and helpful information, or indeed it might be a referral to external sources where the requirement is for specialist expertise. The advice areas include today's subject, workforce and recruitment, but also some of the hot topics, import and export, supply chain, and some of the lesser known ones like data and information, legal, IP and regulations. So the free to access service is designed to assist Hertfordshire companies. It's about minimising business disruption caused by EU transition, but also it's about looking for ways to take advantage of business opportunities coming out of transition. So contact, it was mentioned on the slides, you go online, inquiries at hertsgrowthhub.com, complete a simple registration and then follow the link through to the transition team. I can't promise we have all the answers. If you look at the range of subjects and the complexity of each one, we don't know everything there is to know, but we will certainly do our best to help any business resolve any transition issues that they may have. So please make use of us. That's it. Thanks.
Great. Thank you, Peter. And can I just emphasize the same? Yeah, we're not experts in everything. We have our experts such as Tom in particular areas, but this is such a big topic. We can't be expected to know everything, but we know people that can, hopefully. And on that subject, just to sum up, on the 23rd of February is the third in this series, and we're covering GDPR, intellectual property rights and data protection. With that one, we have Longmore's on that one, so the early experts in that area. That's also at 11 o'clock, so 23rd of February. If you're interested, or please pass it on to your legal team. I think really with the time, well, rapidly approaching 12, I don't think we've got any more questions for Tom. Actually, Tom, yeah, there is one last one for me. This is the other way in a sense, and I know there's a couple of people, participants who have been asking this sort of question. I think I know the answer. I've looked on gov.uk, but if you're happy answering, because I know it's the other way, and I know you said that every country is slightly different. But if you own a company, you've got a company where you've got people actually needing to go to Romania or Germany to do a specific job, set up for an exhibition, carry out some work for a good period of time, repair work, etc. That's all covered, isn't it? You can do that under, you don't have to, there's a visa, obviously, I assume you apply for, but that's covered under the rules. Is that
well, as I say, everything is, those activities are dictated by the immigration rules for each particular country, and I think within the within the trade deal that was agreed, there is a table which roughly sort of tells you what things are permitted in which countries. So in some countries, I can't remember where it was, but there was one country in particular which seemed to need a visa for anything that wasn't just tourism or visiting family, whereas others are far more liberal in terms of what you can and can't do. We are treated now in the EU as third country nationals, so the 90 days out of 180 rule will apply, and yeah, you will need to look carefully at the rules for the countries that you're going to be in to make sure that you're not going to breach their immigration laws.
Yeah, end up in prison or something. No, that's great. Sorry to hit you with that one, but it's one that was in my mind, and I know we do keep being asked that, but say it's all under gov.uk, I think. Brilliant, thank you so much. Right, well, just to literally sum up, I hope that was enjoyable for everybody, and I learned a lot from it, as I'm sure you all did. It has been recorded, as I said at the beginning, and will be on the Herts Chamber website shortly. Peter, I think I'm right in saying it will also be on your website, I'm guessing. Is that, yeah. It's right, thank you. That's brilliant. And I'd say everyone at the beginning who answered on the poll that they would like to be in touch with Herts Growth Hub, then they will be. So stand by for contact from them. I've given you the rundown for the next webinar, so 23rd of February. And really, I think it's all that's left for me to say is huge thanks to Tom from VW. And your expertise. Do use him because he's a valuable source or asset. Thanks also to our colleagues, say at Hertfordshire Growth Hub, Peter and Lisa earlier, and have a good rest of day. I think it stopped snowing here now, so enjoy the rest of the cold day, and good luck going forward with your EU queries and everything else. And I say we're here, as indeed a Herts Growth Hub, should you need us. Thanks very much indeed. Bye-bye.